India, and particularly lawyers, owe an immense debt of gratitude to the late Justice H.R. Khanna, and perhaps the best way to repay that debt, albeit in tiny measure, is to perpetuate his memory by organizing a lecture series to preserve the values embodied by also propagating the values he cherished. Just 2 years ago, we celebrated the anniversary of the judgment in Keshavnan Bharati by bringing out a souvenir which was released by none other than the present Chief Justice of India, Honorable Mr. Justice B.R. Gavai. The judgment in Keshavnan Bharati's case is synonymous with Justice H.R. Khanna, who propounded the doctrine of basic structure. The judgment in St. Xavier's College versus State of Gujarat is another landmark in his repertoire of judgments, where the Supreme Court was called upon to decide the protection of minorities conferred by Article 30 of the Constitution. The consistency in his thought process and independent mind are unmatched. Today's event is a culmination of that meeting. The inaugural of late H.R. Khanna Memorial Lecture on the occasion of his birth anniversary is delivered by Honorable Mr. Justice Oak, who in several ways is an individual very similar to Justice H.R. Khanna.
Today we have gathered here to celebrate an illustrious and notable career of Justice Hansraj Khanna, whose name is woven in the very fabric of the constitutional story, a story of courage, conscience, and quiet defiance in the face of overwhelming pressure. He studied law at Lahore and began his legal practice with modesty and diligence, never chasing the glory, but always committed to fairness. After partition, Justice Khanna rebuilt his career in Delhi and eventually rose through the ranks to become a judge of Punjab High Court. In 1971, when he reached the Supreme Court of India, it was his quiet strength that would be tested as the most turbulent moment in India's democratic journey. During the emergency declared by the Prime Minister Indira Gandhi in 1975, civil liberties were suspended, censorship was imposed, and thousands were jailed without trial. The Supreme Court, which was considered to be the only last hope for countless citizens, in ADM Jabalpur versus Shivkant Shukla, the question that arose for consideration was hauntingly simple. Did citizens have any right at all when the emergency is in place, or whether all the fundamental rights, including the right to life and liberty, stand suspended? Could someone be detained without trial, seek judicial relief? 4 of the 5 judges on the bench answered in the negative, saying no. They ruled that during emergency, even the right to life and liberty under Article 21 could be suspended. Only one judge stood in dissent. It was Justice Khanna. Alone, he wrote a judgment that has since become a moral compass for the judiciary. He declared that the right to life is not merely a constitutional right, but it is a natural right, a human right. Even in absence of Article 21, the state cannot take away a person's life or liberty without authority of law. He called detention of trial an anathema to liberty and reasoned that the Constitution cannot be read as a license for state tyranny, even in exceptional times. He knew the cost of his dissent. At the time, he was the senior most judge and the natural successor to the most coveted post of the Chief Justice of India. But obviously his judgment displeased the government and he was bypassed for the said post.
It is indeed a privilege to be a part of this august gathering on this special day, the birth anniversary of Justice H.R. Khanna. A lecture dedicated to the theme of judicial independence feels especially fitting given that Justice Khanna himself stood as a resolute symbol of that very ideal. The principle of independence of judiciary is deeply enshrined in our constitution, and a judicious ethos is not merely a structural doctrine. It is a very soul of justice and fairness. When we speak about independence of judiciary, the immediate thought that comes to our mind is a freedom from political influence, and rightly so. Our constitution, through its careful crafted provisions, insulated judges from political pressure. It provides security of tenure, service conditions are fixed, the threshold of removal of is deliberately kept very high. This institutional independence is not a gift but a deliberate constitutional guarantee. It is a cornerstone of doctrine of separation of powers. Indeed, to large extent, this form of independence is preserved. Our courts have time and again risen to protect the constitutional values. Whether it is for the defense of civil liberties during the time of emergency or the vigilant guardianship of fundamental rights, the judiciary has shown its strength to remain unswayed. But the conversation cannot end there. True judicial independence also requires freedom from within, from the invisible hands of one's own prejudices, from the unconscious sway of personal opinions, from biases that may cloud objectivity. This is the subtler and in many ways the more formidable challenge.
During the time of emergency, I was a student activist in Kerala, and as far as emergency is concerned, I am very much practical problems faced at that time in my mind. During the time of emergency, our Supreme Court, so many examples are there. Palkiwala thrown away I am using the word thrown away with great care. The wakalat of the person responsible for declaring emergency. And some other lawyers also, Bombay, at that time, there was a solicitor, he also resigned from that post. And so the incidents are there. As far as HR Khanna is concerned, you see, when this ADM Jabalpur case was referred by the welcome speaker, you see, HR Khanna, while sitting, he was the senior most judge, of course Chief Justice was also there, put a question to Attorney General at that time, Mr. Nirande. He posed the question, suppose a police officer taking a person to custody, legally taken to custody, and thereafter because of his personal enmity to that person, if he is murdered or is beaten and murdered, can this court interfere? Nirande's answer, recorded by so many books, that no, can't interfere. This court can interfere unless and until the emergency is withdrawn. So this is the basic thing happened at that time.
I consider myself to be extremely privileged and lucky to be part of lecture series in the memory of late Hansaraj Khanna. Today I am supposed to speak on independence of the judiciary. Since I am going to address you in the context of life and times of Justice H.R. Khanna, naturally the focus will be on the days of emergency. But to begin with, I must clarify that when it comes to independence of judiciary, irrespective of the party in power, irrespective of the fact whether there is emergency or not, there is always a threat to independence of justice, independence of judiciary. And therefore, the members of the judicial fraternity, namely the judges and members of the bar, have to be always alert and ensure that independence of judiciary is not affected in any manner. I remember to have read one article in New York Times. It was article dated 30th April 1976. It was editorial written perhaps 4 days after the judgment in ADM Jabalpur vs. Shukla was pronounced. And very interestingly, in that editorial of New York Times, it is said, if India ever finds its way back to the freedom and democracy that were proud hallmarks of its first 18 years as an independent nation, someone will surely erect a monument of Justice H.R. Khanna of the Supreme Court. That's what New York Times says. His monument was not erected. His portrait was displayed in Court Hall number 1 of the Supreme Court. And for me, it was not necessary to have a monument of Justice H.R. Khanna, because he will be forever remembered for what he did for upholding the independence of judiciary and independence and also fundamental rights of the citizens. But for his supersession, he would have become Chief Justice of India on 29th of January 1977 and would have occupied the office till 2nd of July 1977. But I must also say here that there are judges and Chief Justices of the Supreme Court who have been already forgotten. But there are a large number of judges of the High Court who never went to the Supreme Court and they are remembered forever. There are judges of the Supreme Court who did not become Chief Justices of India, but they are remembered forever. Giving example of our Bombay High Court only by way of illustration, we had Chief Justice M.C. Chagla, Justice Chittatosh Mukherjee, Justice P.D. Desai, Justice M.L. Pense. These great judges never went to the Supreme Court, but we fondly remember them. I can add many names to that, like Justice Bhima Dalal, Justice Lentin, and so many other names can be added. Same is the case with Supreme Court judges. Everybody knows, we remember H.R. Khanna, we remember Justice Vivian Bose, we remember Justice Krishna Iyer, we remember Justice J.R. Mudalkar, who much before Keshavananda Bharati has written about basic structure of the Constitution. We remember Justice Hegde Grover and Shellart, who were superseded. Since we are in the context of days of Justice H.R. Khanna, I want to start with Keshavananda Bharati. Keshavananda Bharati, of course, all of you know. The basic concept of basic structure of the Constitution introduced by that judgment by majority. I want to tell this for the benefit of the students and young lawyers that I personally feel as a student of law that this is one judgment which kept democracy in India intact. And there are fascinating stories about this judgment. Within 3 days of the pronouncement of the judgment, 3 judges, Hegde, Shellart and Grover, they are superseded. And that paved way for Justice A.N.A. to become Chief Justice. I must tell you one more thing. When the emergency was proclaimed, there was only one survivor of the majority view in Keshavananda Bharati, that was Justice H.R. Khanna. There is something interesting about Keshavananda Bharati. I am not going to repeat what was said in Keshavananda Bharati. I leave it at that by saying that it is one judgment which even today continues to protect the democracy in India. As a consequence of supersession, Justice Ray became Chief Justice of India. In normal course, he would not have become Chief Justice of India because perhaps he would have retired during the tenure of Justice Grover. I believe in November 1975, he suddenly constituted a bench of 13 honorable judges of the Supreme Court for the purposes of reconsidering or reviewing Keshavananda Bharati. And I read that famous argument by Nani Palkhiwala that he told the bench that the case before you does not involve basic structure at all. And advocate generals of various states said that nobody has requested for review. Very vivid account of what exactly happened before that bench is mentioned by Justice H.R. Khanna in his autobiography. It is worth reading. And ultimately, the bench was dissolved. This is very significant to be remembered by students of law. And look at the sacrifice involved. 3 judges had to forgo the post of Chief Justice of India. As we are talking about independence of judiciary, I want to tell with great deal of emphasis for young members of the bar and young students of law that even before Justice Khanna's dissent, at least 3 to 4 high courts took a very bold view For the benefit of young students, I want to tell you something. Emergency was proclaimed on 25th of June 1975. On 27th of June, the President exercised power under Article 359 and declared that remedies under the Constitution for enforcement of fundamental rights under Article 14, 21 and 22 shall stand suspended. Whereas at that time they had forgotten Article 19. So a similar order was passed in relation to Article 19, I believe, on 8th of January 1976. The argument before various high courts, I am going to talk about only Bombay High Court and of course Madhya Pradesh High Court. I believe it was Justice Sen who had taken the view that habeas corpus petition was maintainable, and that led to the famous judgment in the case, famous or infamous judgment in the case of A.D.M. Shukla. In Bombay High Court, there were bold judges. There was one judge who dealt with a case where the government did not permit, the Commissioner of Police did not permit a protest meeting to be held for protesting against the emergency. And notwithstanding suspension of remedy to enforce Article 19(1), the learned judge boldly held that this is completely illegal. There are judgments, the very famous judgment by Justice Tulsapurkar. When I talk about this right to protest, this happened in emergency. I came across a case as Chief Justice of Karnataka High Court in 2020 or 2021 when somebody wanted to protest against CAA, Section 144 of CRPC was invoked. So in those days, the rulers may have relied upon the emergency powers, but the tendency continues, and I had to set aside that order which prohibited agitation against the CAA. There was one more very famous judgment by Bombay High Court, and that judgment is worth reading, where the government advocate stands up and makes an argument that tomorrow, if order of preventive detention under the MISA, Maintenance of Internal Security Act, says that the detainee should not be provided food, even in that case he cannot maintain a petition under Article 226. Consistently, Bombay High Court, at least 4 judges, I think Justice Bhima Dalal, Justice Tulsapurkar, Justice C.S. Dharmadhikari, they took the view that there is a rule of law. If an order of preventive detention is mala fide, if it is illegal, it is not within 4 corners of law, petition under Article 226 will be maintainable. There is a famous case, there was a Marathi weekly, very famous Marathi weekly, started by none other than a great socialist leader, Sane Guruji, who was follower of Mahatma Gandhi. About 11 issues of that weekly were forfeited by the government. Justice Tulsapurkar interfered and he said that this is something blatantly illegal, and Article 226 was invoked. There is very interesting thing the students of law must observe. See the combination of bench which dealt with A.D.M. Jabalpur versus Shukla. Of course, Justice A.N. was the Chief Justice, and you will find that except for Justice H.R. Khanna, the other 3 who were part of the majority became Chief Justice of India, but Justice H.R. Khanna never became Chief Justice of India. I don't know whether any significance can be attached to it, but still it is worth considering. And then came that pronouncement of law by Justice H.R. Khanna. And I want to read only few passages from his famous dissent. As Honorable Governor said, that when Justice Khanna wrote this minority view, he was fully conscious of the fact that he is writing that view at the cost of the post of Chief Justice of India. Please remember, I want to appeal to the young students, please remember the sacrifice made by him. Not only him, as I said, there are several judges who may not have reached the pinnacle. But if you look at the history of judiciary, there were attacks on judiciary, those attacks continue even till today. But there were fearless judges who defended the judiciary, and their only object was to ensure that the democracy and constitution must survive in India. Now, very interestingly, what Justice Khanna holds here is that he says that Article 21 is not the sole repository of freedom. And that's a beautiful analysis made by him. Perhaps same analysis was made by Justice Tejjus and Justice C.S. Dharmarikari sitting in Mumbai. What he says is in paragraph 530, even in the absence of Article 21 of the Constitution, the state has got no power to deprive a person of his life or liberty without authority of law. This is the essential postulate and basic assumption of the rule of law and not of men in all civilized nations. Without such sanctity of life and liberty, the distinction between a lawless society and one governed by laws would cease to have any meaning. The principle that no one shall be deprived of his life or liberty without the authority of law is rooted in consideration that the life and liberty are priceless possessions which cannot be made the plaything of an individual whim and caprice, and that any act which has the effect of tampering with life and liberty must receive sustenance from and sanction of the laws of the land. Article 21 incorporates an essential aspect of that principle and makes it part of fundamental rights guaranteed under Part 3 of the Constitution. It does not, however, follow from the above that if Article 21 has not been drafted and inserted in Part 3, in that event, it would have been permissible for the state to deprive a person of his life or liberty without the authority of law. Then he says, I am unable to subscribe to the view that when right to enforce the right under Article 21 is suspended, the result would be that there would be no remedy against deprivation of a person's life or liberty by the state, even though such deprivation is without authority of law or even in flagrant violation of the provisions of law. The right not to be deprived of one's life or liberty without the authority of law was not the creation of Constitution. Such right existed before the Constitution came into force. The fact that framers of the Constitution made an aspect of such right as part of fundamental right did not have effect of the independent identity of such right and of making of Article 21 to be the sole repository of that right. I am unable to agree that in view of the presidential order in the matter of sanctity of life and liberty, things would be worse off compared to the state of law as it existed before coming into the force of Constitution. So therefore ultimately what he holds is that the liberty existed even before Constitution came into force. It was essential part of rule of law, which is part of our jurisprudence. Now you have to understand this in the context of days of emergency when Justice Khanna wrote this dissenting opinion. We are talking about challenges in emergency. There were huge challenges because of the law which was prevailing. There was order under Section 3, Article 359. And there was censorship. I am told, I am not sure, I tried to find out material. Even the minority view of Justice Khanna was censored, it was not allowed to be published. That's what I read somewhere, but I could not get those orders. So the time differs. The persons in power are different, but ultimately it is irrelevant who is in power. There is always a tendency, a natural tendency on the part of those who are in power to tinkle with the independence of judiciary. And therefore, I thank the Goa Bar Association for starting a lecture series in the name of late Justice Hansaraj Khanna, because every year when this lecture is held, we'll be able to convey message to the young lawyers, to the members of the legal fraternity, how important is judicial independence, how important independence of judiciary, and how important are the sacrifices made by judges, the great judges of those years. I close by quoting what Justice H.R. Khanna has said in his autobiography, and this according to me sums up what his philosophy was, what was his thinking. At one place in his book he says, there arose a feeling of some satisfaction for having not faltered at the crucial time from what I believed was the correct course. The fact that it resulted in foregoing and losing the office of the Chief Justice of India did not hurt very much, for such consequence was expected from the moment I prepared my judgment in the habeas corpus case, and also because many others have paid much greater price for following the voice of their conscience. Undoubtedly, those moments were not without a tinge of sadness, which invariably is there at the time of parting, whether from a career of a life or from a dear one. It also happens that in such moments of crisis, in the moments when the curtain is falling on a major part of one's life, one has the consciousness of having done what one believed to be right thing. One gets sustenance and support from inner and hitherto unknown reserves of strength. See the humbleness of this man. He says that my sacrifice is nothing. The earlier judges have made much more sacrifices. And I think this one passage in his book sums up his philosophy, his thinking, his approach to the life. And I think if we read this passage, I think it will be education for young members of the bar and young students of law.